This video will discuss the steps that have to be taken before a legal action can be started for construction defects. The first thing that has to happen is that the association has to notify each unit owner in writing at least 20 days before any meeting where they're going to consider starting a civil action. And there has to be a vote or written agreement required, and it's a majority rule. There is an exception where there's actions to enforce assessments, enforce governing documents, vendor contracts, counterclaims, or protect the health, safety, and welfare. Those do not require that majority rule vote. When it comes to ratifying unauthorized actions, if the association files a civil action without approval, they have to ratify it within 90 days. If they can't secure a vote after a good faith effort, they should dismiss the action without. And then before filing or ratifying, at least 10 days notice before commencing or ratifying an action, the association must mail all unit owners a written statement with a reasonable cost estimate, a breakdown of pros and cons, and then any disclosures that are required when selling the property. Only units owners have the power to request a dismissal. No outsiders can knock out. If a civil case resolves with a settlement, the executive board disclose its terms and conditions at the next regularly and the settlement to avoid complying with the statute. So here's the timeline at a glance. Step 1, notify the unit owners of a meeting to consider civil action at least 21 days before the meeting. Step 2, there has to be a 10-day before filing or ratifying an action. And then step 4, the board must disclose the settlement details. When it comes to resales, there has to be a statement by law provided in the resale package that discusses any pending or current litigation of the assessment, which could then make sales of those units more challenging because some lenders are familiar with the litigation process.